Good afternoon and welcome to our webinar. My name is James Vann. I'm one of the attorneys here at Vann Attorneys, and we're going to be talking today about new laws that are in North Carolina. So we try to do this every year. I'm not sure, we may not have done it last year. We were preparing for this, I thought about it. Maybe it just helped me remember the years we've done this before. We used to do this, in a session we used to call Hot Legal Topics, where we'd have like a 3 or 4 hour event, and we talk for an hour or so about new laws. And so it's sort of fun to do these through webinars. I know we hear from a lot of you, and we're thankful that these are helpful for you. But we're going to be talking about new laws in North Carolina that the legislature passed last year. A lot of them either came into effect last year or this year. And just for a little bit of homework, if you have a question, you may submit it using the GoToWebinar control panel on your screen. You can submit it there, or if you want to send it to an email address, which is webinar@vanattorneys.com. Again, we really hope this is helpful for you. And I'll be honest with you, as we were preparing for this, the challenge is because there's such a wide variety of businesses that attend, trying to make sure we hit something for everybody. So I'm hoping that we'll hit something for you and your business that's helpful to you. As we get started, I want to say a really special thank you to the North Carolina Bar Association. Our Bar Association has a lobbyist that's primarily responsible for the North Carolina Bar Association. And what they wind up doing every year is they do a study or do a summary of the new laws that were passed by the legislature. And so a lot of this information has come from them, and we've just used their information. Some of it has come from the North Carolina legislature, some of it's just from public records, but I want to say a big thank you to the Bar Association for some of the slides that we're using. So let's jump into this. If you will remember, a lot of you remember the legislature early on saying that they wanted to streamline some of the licensing boards and the commissions that are across North Carolina, and Lord knows it covers a wide variety of business type ownership. So they went through and said, the bill what they really did was they were trying to eliminate provisions that broadly criminalize violations of the licensing board and commission rules and make some technical changes. And they also actually got rid of some boards. But the changes regarding the elimination of provisions that criminalize certain violations had to do with the Banking Commission, Cemetery, the Private Protective Services Board, the Alarm Systems Licensing Board, Medical Care Commission, State Board of Examiners or Nursing Home Administrators. Those were a few. Most of these laws came into effect December 1st. And the reason I mention that is we have some clients that fall in most of these areas, and so that might be of interest to some of you having to do with license. And there were some other changes as well. There was another change came through House Bill 650. So if you see HB, that refers to House bill, or if you see SB, that refers to Senate bill. So in case you want to go find the bill, or you can let us know, we'll find it and send it to you. So there was an omnibus DMV bill, and one of the things that it made changes to was that the laws relating to motor vehicles, the dealers and manufacturers, and what kind of information they could process, how they processed it. One of the really interesting things I thought, and it actually applies to everybody, not just to dealers, is that current law prohibits any person from making color photos or reproduction of driver's license and other ID cards by providing an exception for licensed lenders and motor vehicle dealers who make copies in the ordinary course of business for loan applications. So I know a lot of you who have a credit situation with your customers may make copies of the driver's license or other ID cards. Thankfully, this law now gives us an exception which says that you can do that, right? The current law prohibited it. Now you have the ability to do that and safeguard that information. And so a lot of you I know already have that, but if you do collect it, please make sure you're safeguarding it, because it's probably electronic is my guess. and you want to make sure that you're taking good care of that. So one of the other major changes that they did, they really modified a lot of the Business Corporation Act, some of the statutes having to do with business corporations. One of them, Section 1, extended existing provisions relating to voting of the shares held by subsidiary entities that are not corporations. So the reason we share some of this information with you, we've had actually a large number of cases over the last 2 years dealing with small companies, right? And it really is a fight among the shareholders or the board of directors, that kind of thing. So a lot of these are really pertinent. For example, in Section 2 of the changes, it clarified that the authority of the board of directors to fix the compensation of directors for services in any capacity or as a director. So again, the board of directors gets to do that, not the shareholders, right? Section 3 said that, except as otherwise fixed in the articles of incorporation or the bylaws, a majority of a board of directors constitutes a quorum. So again, unless you've got it listed in the bylaws or operating agreement, then a majority of the board of directors constitutes a quorum. If you don't have it listed in your bylaws, then of course you look to state law, or your operating agreement. Section 4 talks about the board of directors of the corporation with a single class of shares, that they can change the corporate name without shareholder approval. And I really thought that was interesting. I want to find out more about why that's included. But to think about it, right, the board of directors being different than the shareholders, it can be the same or necessarily doesn't have to be, but the board of directors can change the name of the corporation without the shareholder approval, which I thought was really interesting. Section 5 provides that in a superior court proceeding brought by a shareholder seeking an appraisal, the shareholder bears the burden of proof in showing that they are entitled to appraisal rights. So if the court determines that the shareholder is not entitled to the appraisal rights, the court's required to dismiss the proceeding as to that shareholder. And we've actually had some cases very similar that pertain to this actual section in the last year. So it really does, this stuff matters, right? Another part of the modification of the Business Corporation Act was in Section 6, and it makes a number of changes to the law regarding corporate records and shareholder inspection rights. I'm not going to go through all of those right now, but as a shareholder and as a owner of a corporation, you have certain rights to look at the documents, right? If you're not in operation or you're not in control, you have certain rights. So they changed some of those rules. Most of these changes having to do with the Corporation Act came into effect October 1st of 2021. So just have that in the back of your head. If you have any questions about that, or if you have any problems with it, let us know. Another change they did was they modernized the remote business access. So when COVID hit, a lot of companies and a lot of nonprofit organizations, homeowner associations and so forth were struggling with how do you have meetings, right? Because we couldn't meet in person, and the law, most of the laws at that point did not authorize remote business access. So they modified the Business Corporation Act to say that corporation meetings of corporation shareholders, nonprofit corporations, homeowners associations, and so forth, they can have the meeting solely by means of remote participation. It also exempted not-for-profit corporations formed prior to that act from being required to have at least one class of shares of unlimited voting rights. Again, these are some things that were really existing many, many years ago, and so they sort of cleaned all of that up. So if you are on a homeowners association, or I know we help a lot of folks, especially nonprofits and other business entities, manage how are they having their meetings, right? How do they have their ownership meetings or their bylaw meetings? Thankfully now they have the statute there, and actually right before that, I think the governor signed a bill. The governor signed an emergency directive that gave a lot of the companies the rights to do that temporarily through COVID, but now that's become state law. So hopefully that helps. So I always love looking at the legislative changes that you see coming through, because a lot of times it will tell you what is to come, right? With business interests coming down the road. So this is a bill that's, it says neighborhood occupantless vehicle. Well, by the way, when you type in occupantless, this is not a word, right? So I put a hyphen in it so that spell check wouldn't give me a hard time. But they define neighborhood occupantless vehicle as a specific type of fully autonomous vehicle used to transport goods without a human occupant, and authorizes its operational highways with restrictions and equipment requirements. So think about this, all of a sudden you're going to see occupantless vehicles in your neighborhood delivering packages, is my guess, right? So they went ahead and approved it. Under the bill, the neighborhood occupantless vehicles would also be subject to the operation of motor vehicles laws in North Carolina. This became effective December 1st of last year. So the reason I share that with you, it's number one, it may hit some of your businesses, and number two is it's sort of interesting for us as individuals and as consumers. There was also a change in the Board of Architects and Interior Designers statutes, and it gave a framework for governing the scope of practice for interior designers, and it actually gives them authorization to apply for building permits for interior construction projects, and gave certainly for fees, obviously, for interior design and registration, and for the architecture license. So this is a first for the North Carolina framework, in the sense of trying to give the interior designers the ability to actually issue or to apply for building permits. Really interesting that that's happening, and because that's a growing field in and of itself. So I know some of our clients are involved in that, so I thought that might be helpful and pertinent to you. They also made some changes to building code and development reform. The state licensing board for general contractors now is authorized to require criminal background checks for general contractors, license applicants, to approve providers and instructors for general contractors continuing education classes, and require affiliated instructors to be registered with the board. Additionally, if the board prevails if they have a reason they need to go after someone for injunctive actions enforcing the rules for a GC, so let's just say, for example, that there's someone trying to practice general contracting and they're not licensed, or if the GC is doing something in violation of the rules, and the state board has to file a complaint for injunctive relief, the court must award the board up to $5,000 if they do that, plus the court costs, and they win on it. So it was really interesting that they did that, and I'm sure the AGC was a big part of trying to get that pushed through. I don't know all the history to it, but it's really interesting. Again, this is something that I thought was really interesting. It's a prohibition for possession of a skimming device. So the definition of a skimming device was added to the Financial Transaction Card Crime Act, and it makes the possession, sale, or delivery of a skimming device a Class 1 felony. So skimming devices is what criminals use to skim the information off of credit cards or debit cards. So not only is it a crime to use one, right, and to actually skim the credit card information, it's unlawful to even possess it. I don't think our clients have that issue, but I just thought that was really interesting that they have classified that now as a Class 1 felony. So there were some other changes that I thought y'all might be interested in. As you know, once you get a judgment against someone who maybe owes you money, if it's an individual in North Carolina, before you could have an execution issued to send the sheriff out to look for assets, you have to send what's called a notice of rights to claim exempt property. So one of the changes that they made was that they removed the requirement to serve the notice of rights to claim exempt property to a judgment debtor before the writ can be executed or possession can be issued if the exemptions are inapplicable based off of statute, which means in essence if there's federal tax liens, child support, and a host of other things. And it deleted the provision that states that the exemptions provided in the North Carolina Constitution are waived if the judgment debtor fails to request the hearing within 20 days. So, and the reason I bring that up, especially this last piece of that, is we deal in this a lot, right? So it's going to be interesting to see how the courts interpret this legislative change, especially where it says that it deletes a provision that states that the exemptions provided by the state constitution are now waived if the judgment debtor fails to request a hearing within 20 days. So that's been a law since I've been practicing, been a long time. I really would love to know the history as to why they introduced that piece of it. But in essence, what it was saying is that they waived their constitutional exemptions if they didn't ask for a hearing. And it's also if they don't make the exemptions, they waive them. So I hope that that's what's going to continue in that piece of it, but we'll wait and see. A few other changes they made about the court system was they allowed for the court proceedings after June 18th to be conducted by video, audio. And I will tell you, there are a lot of courts across our state now where we have video conferences for court hearings. That's a real plus for, I think, for everyone. And not all hearings are conducted that way. Sometimes there are some issues that you need to be in front of a judge, and most of the judges, thankfully, are agreeing to that. But quite frankly, it really helps everybody. It's more economical. Ultimately for the clients, it's pretty convenient for all the parties involved. Sometimes though, you just want to be in front of the judge so that you can see facial interaction and body language, and thankfully they have been very open to that. The other thing is, and I know many of you we've been in mediations with, they have now made it a statutory requirement that when you are mediating a case and it settles, that there's a written settlement agreement that is to be signed by all the parties to be that's going to be held against, right? To make sure that it's in writing. Most mediators do that, and sometimes I think what happens is people are it's the end of the day and they're scrambling trying to finalize something, and they just, okay, we'll sign it later, and they just never do. Well, now they've said it's got to be signed, right? So it's a good change. So one other change that was enacted in 2021 is called the North Carolina Farm Act. And the reason I chose this piece here because I thought it might be interesting to you, either in your business or personal life, and it has to do with cutting down of timber. Y'all, you wouldn't think that that's a problem, but it really is. We get, I don't know, we probably get 6 to 12 calls at least per year of people saying, hey, so-and-so cut down trees on my property without permission. Well, to give you the understanding now, it's a class G felony, if someone knowingly and willfully cuts down, injures, or removes timber owned by another person without their consent or other legal authority, unless it's good faith exception having to do with the power company, which doesn't apply to us, and to buy timber directly from the owner of the timber and fail to pay by the date specified in the written agreement or within 60 days. It requires the defendants convicted of a larceny of timber to pay restitution to the owner of the timber, and also, get this, allows the owner in civil action to recover triple the value of the wood, timber, or shrub or tree from a person who violates the statute. And I'm telling y'all, I would have never ever thought that this was that big of a problem, but it really is. So this actually, and some of this has already been legislatively passed before. They just clarified it and actually given the owners of the timber more actionable rights. So you can have treble damages, which again, that's can get expensive. Excuse me. So for the landlord and tenants, I know we have a lot of our clients are landlords and deal with tenants issues. It clarifies and then reaffirms what was already statutory authority for landlords to recover out-of-pocket expenses and litigation costs if they are trying to remove the tenant from the property. And it makes various other changes to the statutes. It also reaffirms the existing law that provided that landlords are permitted to charge out-of-pocket fees, the attorney's fees, court costs, that kind of thing. And all of that went into effect July 2nd, 2021. Interesting enough, while there was also moratoriums on landlords from doing that. If you have any questions, I mean, the landlord-tenant area of practice across the country, but certainly in North Carolina over the last 2 years has really been sort of a really tough area. We tried to combine these things, hopefully, that gives you some information to help you. And we didn't want to overbear and give you too much information, but I hope that that's helpful to you. If you have any questions, please let us know. We'd be delighted to answer those questions for you and serve you. Thank you for letting us be a part, and we're thankful that you signed in today. Hope you all have a great rest of the week.